Alors bonjour et bienvenue à tous à cette série de conférences de la section de droit civil. Merci d'être là en si grand nombre. I'm very pleased to welcome this week Nick Blomley. Nick is a professor of geography at Simon Fraser University in Vancouver. As a geographer, Nick has a general interest in law and in property and land. He's one of the founders, but also one of the most prolific scholars in legal geography in Canada, certainly. He's worked on different projects throughout the years, including property in the city, Aboriginal people's rights, panhandling and the regulation of public spaces. And in the last 2 years, we've been working together on a project on area restrictions imposed by criminal courts in bail and sentencing. But he's also involved in a recent project on the liquidation of Japanese Canadian property after World War II. So it's a great pleasure to welcome him in. Thank you very much for being here. And his title, the title of his talk today is The Space of Property.
Thanks, Marie-Ève. That's wonderful to be here. Thank you for the kind invitation. What I want to talk about today is one of the many projects that Marie-Ève described, relating in particular to an, I think, under-documented but crucially important moment in the long path toward reconciliation between settler society and this settler society and First Nations, that being the treaty process in British Columbia, and I'm calling it the space of property. I am, as Marie-Ève said, a geographer. I'm not a lawyer, but I have an interest in law. I have a particular interest in land, property in land. Its meaning, its definition, its geographies, and the way it gets performed in the world. I've looked at property in multiple empirical settings. I'm a social scientist, so that's my first inclination, including things like gentrification, street begging, gardening, everyday gardening, and also in relation to public space and area restrictions. This very exciting project that Marie-Ève and others and I are working on is an example of that. But I hadn't really spent much time engaging with what is, in my part of the world, the biggest property question of all, that being who owns the land upon which British Columbia, or the place now called British Columbia, currently stands. In a settler society like Canada, of course, this is a very vexed question. It's particularly unfinished business, as they say in BC, because with very few exceptions, treaties were never signed with Indigenous peoples. Thus, unextinguished Aboriginal title bumps up against the claim of Crown title. A treaty process initiated in 1992 and grinding very, very, very slowly forward, and there's only been a couple of treaties actually concluded, is intended to address this embarrassing legal gap. Property is at the center of the treaty process. It's the major impetus behind it, as we'll see, but it's also central to it in another, I think, more interesting sense. As we'll see, one sticking point concerns the very definition of property itself. What does property actually mean, or what can it mean? So I try to follow this through with a series of interviews with key players, and this isn't a community-based project, I should make that very clear. I'm engaging with the legal actors on both sides, and it's a thoroughly legal process, whether on the part of First Nations negotiators or Crown negotiators, as well as I follow this project through with collaboration with a group called the Hulkaminum Treaty Group, who are on Vancouver Island. And I was very fortunate to gain access to basically their archive on what I'm going to call the status of lands question, which is one of this crucial focus that I want to follow through here. Central to the Crown's mandate, which he saw as ill-suited to reconciliation. Because what that quote doesn't tell you, and what he does more in the interview more generally, is he worries that rather than a space of in-betweenness, the Crown is seeking to convert Indigenous title into a secure form of common law property, the effect of which is to close down that possibility. He disagrees with that. He wants to contest that. And that contestation is the story I want to talk about. That contestation, I want to suggest, is not just a contestation over different interpretations of property. It's a contestation over what property actually is, the meaning of property itself. There's an ontological politics at play here. So we have to step back a little bit, if you'll excuse me. It's tempting when we think about property and when we think about space to do so in broadly realist terms, to attribute to property and to space some reality that lies outside our own interpretations, our own engagements with it. We see this in the treaty process, a conception of common law property, particular fee simple title, as real, certain, solid, and secure, with a view of indigenous property as somehow ultimately unreal, fluid, cultural, unstable. Rather than thinking of property and space as some sort of essence, I prefer to think of property as an effect. The slide here is from one of my postdocs, Brian Egan, took it on one of the Gulf Islands, and in a way, I think nicely captures this sort of other different reading of space and property. This fence, says the seagull, represents the arbitrary line separating provincial from so-called private property. Please respect this consensus reality, thanks very much. Property and space, the space of property, is a consensus reality as an effect. And here I'm borrowing in part from actor network theory, which argues that things take their form and acquire their attributes as a result of their relations with other entities. We're borrowing from semiotics here. You know, cat means cat because cat is not dog, but simple. As a result, there are no inherent stable essences outside the relations that give things meaning. To the extent that objects like property appear to have an object-like form, appear to have a reality, this should be treated as a more or less successful effect or an outcome, rather than something given in the order of things. That which we call property can therefore be thought of as performed through multiple relations, the alignment of multiple resources, whether those are people or ideas, or fences and seagulls, or things, institutions, and so on. Now, everyday practices and beliefs are one such resource, but I think it useful, following recent calls in legal scholarship, to focus on technicalities, legal technicalities, to consider the important and highly specific work of legal practice, of what law does and the way law thinks. And I say this, of course, as a non-lawyer, so please tell me if I'm wrong. Now, one helpful way of approaching legal practice, I think, comes from the comparable work of this guy, Michel Calon. He writes on the market. He's interested in what the market is and how the market becomes stabilized as such. Calon characterizes the market as a, quote, collective calculation device, unquote. Calculation presumes a set of agencies, organizations, and processes engaged in complex interactions, measurements, and comparisons that produce the relational effect that is the market. The ability to calculate, Calon argues, is inherently relational. It's based, for example, on assessments of how others in a market interaction will react. But a market interaction also requires, if calculation is going to occur, that a partial bracketing or framing, as he calls it, of the network be made. You have to create some space within which those interactions can occur. And I'll talk more about that in a second, but just to note that he borrows from Irving Goffman and Goffman's frame analysis, which some of you may have encountered from long ago. Goffman explores how people react to and organize everyday situations, like a seminar. He argues essentially that we draw upon and rely and help reproduce a whole series of frames. You know, so one of those frames is this bizarre process where I get to talk for 45 minutes and you're supposed to be quiet. If you started talking, that would disrupt the frame. He talks about theatre and the way in which theatre is organised. So, you know, you enter into a theatre, you're supposed to suspend your disbelief. I know that's not really a murderer, but I'm to pretend that is. That requires, of course, a very, very skillful form of framing, as he calls it, where we bracket certain things, bring certain things into the equation, and leave other things out. Calon's argument is that essentially meaning is being produced through such frames, that those frames actually are constitutive of meaning in a very important sense, because of course if relations are at work here, the way we organise those relations help constitute meaning. Now framing, or bracketing as I want to call it, and I'll talk about why in a minute if you like, bracketing, while endemic to social life, it happens all over the place, it takes on a particular salience, I think, within legal practice. So what I'm doing here is borrowing from Calon and taking him into law. To frame, or to bracket, as I would put it, borrowing from Calon, is to establish a boundary within which interactions take place more or less independently of their surrounding context. It's a process of boundary drawing. For a property transaction to occur, or a contract to be written up, a framing has to occur. Buyer, seller, object of the transaction have to be constituted as discrete and more or less autonomous objects. All have to be severed analytically, ethically, and so on from their context in order to be treated as separable objects. The notion of Pareto optimality in law and economics requires a framing, and on and on. But bracketing is never easy. Bracketing entails hard work. It requires a lot of work and effort. Relations have to be lined up and stabilized. Sometimes those things appear easy, and there is an easiness that I think deserves our attention, but nevertheless work goes on in the production of that frame. So to call this my paper, as I'm doing now, denies all the intellectual connections and obligations I have to other scholars, the relation I have to the software that allowed me to write it, etc., and so on. But bracketing is never complete. What becomes interesting then is the movement between the frame and that which is outside the frame, what Calon calls overflow or leakages. And we can think about different degrees to which frames are more or less open. So law and society has a different relationship to its object of study than does black letter law. A different framing is at work in those two intellectual fields. But more interestingly, that which is outside the frame very often must be drawn upon for the frame to actually succeed. A contract only works, right, even though there's a rigorous framing, because we assume there's a world of law enforcement and courts and ideologies about fair dealing and so on that come into the frame. And Goffman would say the same point about a theatrical performance, right? We know what murder is, so we go into the theatre, and we see a fake murder being transacted. We're bringing in ideas about right and wrong and so on. A bracket in a sentence severs off that clause in the sentence, but it makes no sense except in relation to the larger sentence of which it is a constitutive part. Now, if property is about relations, any bracket necessarily is going to be consequential. Something's inside and something is outside. Consequently, there's a politics to bracketing, a politics to framing. Not everyone gets to bracket. Not everyone gets to bracket successfully. In that sense, brackets can very quickly become strategic battle lines. We should also not assume that this is a project of simplification, of purification, of disembedding, in the sense that Polanyi talks about disembedding. As we've already said, the work of producing that frame is bloody hard work, right? So it's not simple by any means. It's complicated and messy and contested. But also when we look inside the frame, inside the bracket, we often find considerable heterogeneity, considerable complexity. And that's a theme we'll hopefully see when we now go back, that we believe to here finally, to the treaty process itself. I think the treaty process can be thought of as a struggle over the brackets and thus the meaning of property, of how property is to be bracketed, how it is to be constrained, the degree to which it is to be open or not. Now, the emergence of the concept of aboriginal title is, of course, a very, very long story, which I'm sure you know more about than do I. But clearly the effect of this, insofar as BC is concerned, has been to render crown title, and thus potentially by extension other forms of title, sticky. It's become entangled in ways that it always was entangled, of course. It was from day one, but institutionally there was a separation between those two. But the emergence of that concept has created enhanced stickiness. Aboriginal title becomes a, quote, burden on crown title. Problem is, we don't know what Aboriginal title is. Aboriginal title itself resists framing. It's slippery, it's complicated, it's cultural, it's localized. It's hard to situate within the common law. It's very hard to situate, it seems, within neoliberal frames, although maybe the market's better at this than is the law. The way the state responds to this is through this almost manic appeal to certainty, a language of certainty. I think certainty is a sort of ontological worry as much as it is a categorical worry. This is a quote from the website of Aboriginal Affairs and Northern Development Canada, describing for outsiders the treaty process in BC. It's all about uncertainty, it's all about messiness. The treaty process is to produce something called certainty. Never quite clear what that actually is, but there's a sort of magic that will happen in that process. One technical but highly political dimension to the production of certainty, supposed production of certainty, concerns the nature of the property holding that the First Nation will have in its treaty settlement land. So at the end of the day, the treaty is ratified, dissolved, the First Nation will presumably get some cash back and a piece of land, dirt and dollars as it's called in the treaty process. The dirt is something bigger than the reserve, but it's clearly not the traditional territories that we saw on the map from a few slides ago. So land will be returned to the First Nation. It will not be reserve land. It will not be governed by the Indian Act. It will be held by the First Nation. The question then becomes, how will it hold its land? For the Crown, this is a no-brainer. The Crown has insisted, in line with this sort of logic here, this is the mandate of British Columbia from very early on in the process. The Crown has insisted from day one that the treaty settlement land will be held as a form of fee simple estate. First Nation will hold it as a collective. Fee simple is the best we've got. It's the highest estate known to the common law. It's good for the First Nation. It will allow the First Nation to integrate into the larger society. This isn't a disconnect, it's simply a modification. You can do what you like inside that fee simple, but insofar as the rest of the world is concerned, it's a fee simple. What we'll do is we'll turn the uncertain, the unreal, into the real and the stable. This, however, is seen as deeply problematic for many First Nations negotiators. Worry is that this is a form of extinguishment by other means, and this has proved a major impediment to the resolution of treaties. There are others, but the status of lands question is a big one. This is a quote from the Union of BC Indian Chiefs, who are outside the treaty process. So not everyone's in the treaty process. There are many who have refused to participate. And you can see their language here. It speaks for itself. The effect is to capture and tame Aboriginal title and rights and place them in a cage constructed of words and legal provisions. This closes down, insofar as they're concerned, this Aboriginal title, whatever Aboriginal title is, or Indigenous title, that is, it must be hung on to. Now, the battle over fee simple has gone on for about 15 years, but it's been largely undocumented. In one sense, this isn't surprising. This is a highly technical debate over property forms and common law legal principles. It doesn't seem political in the sense that many people think about politics. You would sure think about law perhaps in a more nuanced sense, but to those who are non-lawyers, this is not, or the politics is going on somewhere else. The treaty process is highly legalistic. It involves legal actors on both sides seeking to come up with a legal document which references legal norms, Canadian Constitution, the common law, doctrines of tenure in states, and so on. Rather than a deactivation of politics, I think this is fully political. This is a struggle about the brackets of property and space, and that state is the very meaning of property and space. So what I'm going to do in the balance of the talk is quickly give you 4 moments in this story, or 4 way stations in this story. The first relates to, based on my interviews and the archive, is based on the First Nations opposition to fee simple. So why is fee simple objectionable, if you like? The second relates to the Crown and the Crown's response to this politics. The third relates to the attempt quickly by First Nations to try and find alternatives to fee simple, which, as we'll see, proves rather challenging. And the fourth moment, which I think is one of the most interesting moments, concerns those First Nations who have accepted fee simple. And I say accepted with scare quotes because, as they'll say, they haven't actually accepted fee simple, even though they had. We'll get to that in a second. Fee simple kind of comes onto the agenda on the treaty process in the late 1990s. So they've reached agreement in principle, they've kind of hammered out the broad kind of terms. Now they get to the nitty-gritty, and the question of the land holding, not surprisingly, is one of those nitty-gritty details. The Crown says fee simple is straightforward, you can take it to the bank, it's a simple, legible, technical device. First Nations say no, it comes with baggage. In a sense, they want to complicate fee simple, reopen the brackets around fee simple. And they do it in a variety of ways, one of which, not surprisingly, is through culture. This isn't our law, this is your law. This is settler law. Not only settler law, it's English law. It comes from somewhere else entirely. It's an alien importation from another culture, another place. So we open up the frame to culture. Here's Robert again talking about this English land law system that would be a complete gutting of any kind of Aboriginal interest based on your own customs, your own practices, your own tradition. But there's a second complication here, perhaps a more worrisome insofar as they're concerned, and that's an opening up of fee simple to politics. And you, of course, know the story around fee simple, but it's an important one that bears telling. What we find if we go into the archive, it's quite fascinating, is this exploration of fee simple. So First Nations negotiators kick fee simple around the room. What the hell is this category? Because they're all lawyers, so they know what the category is. But they really open it up in a very, very intriguing and interesting way. And what they open it up to, of course, is feudalism. It's a feudal concept, not only an alien concept from another culture, but a feudal concept that comes loaded with politics, deriving, of course, from English common law, the legal fiction of the Crown holding the title to the land. William the Conqueror suddenly magically acquires all the title to the land that is England, and then allocates estates, conditional estates, to his various liege lords who allocate it all the way up the feudal hierarchy. This, of course, complicates indigenous histories, indigenous geographies that are not predicated on the Crown. The worry being, of course, that to accept fee simple is to accept the notion that the Crown has granted you the land. Because if it's a fee simple, the Crown must be the allodial holder of the land and then allocates you that interest, that estate in the land. That is seen as somewhat problematic, as you might imagine, for many First Nations. Now, of course, the treaty process recognizes the Crown, right? The Crown sovereignty is not on the table. If you're in the treaty process, you acknowledge Crown sovereignty. But do you acknowledge Crown title? And the blurring between sovereignty and title is one of those brackets that we could talk about later. So this is a quote from the archive, the Hulkaminum archive, where Hulkaminum is kicking this around again and saying, here are various options. They're going back to the community saying, these are our various options. The problem with fee simple is that it implies this hierarchical relationship where the Crown is the lord of the land and the First Nation becomes the vassal, potentially, having a very conditional interest in the land. So what does the Crown do? Well, the Crown, this is a very complicated story, but essentially what the Crown seeks to do is to shore up, or try to shore up and stabilise the brackets that surround fee simple. Make fee simple simple. And there are various dimensions to this, but one foundational move, a bracketing move, which we haven't talked about, is to insist that Aboriginal lands must be held in a form recognisable to the common law. You have to come inside the common law, right? They're only going to accept those forms of holding. It's not going to be something outside the common law because, well, it's never clear why, but of course there's an argument around sovereignty that isn't at work here. So a sharp line is drawn around the common law. Inside is certainty, clarity, and simplicity. Reality. Outside is messiness. Other forms of land ownership are just a lot of uncertainty, quote from a Crown lawyer. So inside is certainty, outside is uncertainty. The problem then becomes, okay, if you're inside the common law, where do you plug that indigenous title? Where do you put that Aboriginal interest in the land that the First Nation is going to have? The Crown, as you can see, this Crown representative says here, the problem is that there are only a few boxes available, says the Crown. This is numerus clausus, if you like, in common law, right? There are only so many places. The best place, obviously, the easiest place, to borrow a quote from one of my Crown respondents, is fee simple title. There are no hybrid spaces. We can't come up with new spaces. Again, John Burroughs would be disappointed. There are no kind of alternative possibilities at play there. So fee simple gets performed through the elimination of alternative categorical possibilities. But it's also stabilized through an appeal to the technical itself. Fee simple is a technical device, and you want this technical device on your side, argues the Crown. Essentially, fee simple gets black boxed, to borrow from Latour. It becomes simply a device. I don't need to know what's inside the device. It's like my laptop. I have no idea how it works, but I know if I put something in, I get a predictable output, more or less. So a black box is a device in which, quote, only the input and output count, unquote, Latour. Fee simple is a useful machine that generates predictable outputs, like economic growth, because of its visibility, right? Everyone knows what it is. You can take it to the bank. These are quotes from, both of these are from a very senior provincial negotiator. If you're going to use your land, First Nation, as a means to develop your economy, the lands are going to have to be understood and recognised by banking institutions, right? Very straightforward argument. It's visible, it's legible, it's knowable, we know what it is. It's also reproducible. One of the worries that First Nations also have is that, well, fee simple is just universalising, right? But indigenous interests in land vary. Hulkaminam has a different relationship to its land than does Musqueam, and so on and so forth. But the Crown has said, no, it's one size essentially fits all, and this creates, as far as they're concerned, reproducibility, harmonisation, sort of the ability to see like a state, because if everyone had their own form of tenure, how would you ever function as a province, as one, the same senior negotiator put it. So it's not a box full of history. It's not a box full of culture, not a box full of politics. It's a reproducible, legible, technical device that fosters certainty and calculation. So those First Nations with worries about fee simple thus find themselves in a very difficult place in all sorts of ways. We don't want fee simple. Where else can we go? We have to plug into the common law. Are there other possibilities within the common law? And what you find is this lively categorical politics that goes on. You see it in the archive, and it's still present in the interviews. Which brackets to use, which categorical arrangements to use. This image here, this is again from Hulkaminam, and so it's a document, as you can see at the top here, where various forms of title are being laid out. We have the simple title in the middle. We have customary case Coast Salish title. This is Hulkaminam, Coast Salish people. They're laying out what historically was in place. They have a lodial title, which we'll come back to in a minute. And then at the bottom, these are the sketches that one of the negotiators in Hulkaminam drew. These are based on whiteboards that are going on. So they're whiteboarding various sort of alternatives. Here's the Indian Act model, right? The Crown holds radical title and then allocates the band has a usufructuary kind of right to the land. That's not available. Here's the current treaty model with the Crown holding radical title and then allocating a fee simple title or estate to the First Nation, which then allocates it to individual band members. But this is the interesting one, right? This is the kind of the other option, you know, the big question mark. The attempt to carve out something different. It's full of little quotes, not surprising. Modified allodial title, because we want that direct relationship, or some sort of, quote, aboriginal model, where title and sovereignty get separated. Right? The Crown can have sovereignty, but we need title. Is there a way to do that? And then you get this box, sui generis, allodial, customary law, God knows, right? That's one of the interesting politics in this other move, right? This attempt to find something different. Where do you go? What's that third box going to look like? What's that elusive First Nation title going to be if it isn't fee simple? And what you find is what Hulkaminam called mirroring, the attempt to find something in the common law that was the analogue to something that was more or less comfortable from the indigenous perspective. Allodial title gets kicked around a lot, but allodial title implicates sovereignty and is seen as problematic. What you then find is a sort of opening up of the black box of common law, trying to dig around in land law, trying to dig around in the very messy 1,000 years of English history around land and how land is understood, to try and find something else which might work. And what you find is, not surprisingly, heterogeneity in that box. It's a box full of a bunch of tricks, a bunch of different possibilities. This is an aside, it's a fun aside, but it's an interesting one. Oodle law. Oodle law, as you may know, is a form of landholding practiced in the Shetland and Orkney Islands off Scotland, in which the Crown is absent. So basically a allodial title. It's basically Viking law, right? There's no Crown. So it's just a straightforward relationship between you and the land. So here's one of my respondents in Hulkaminam. He just gets on the web, he just starts looking around, he finds this conversation around oodle law and says, maybe that's something we can hang our hat on. We're trying to relate it, whatever it is, this third space, this alternative, to English law somehow. Now, in that quest for certainty, is there something familiar to the Crown that they can live with? Maybe oodle law is that possibility. Doesn't really go anywhere, but it's an amusing story. Interestingly, just as an aside, in the Shetland and Orkney Islands, as I understand it, there is an attempt to sort of try and claim a form of indigenous title to the land, and so people in the Shetland and Orkney Islands have been hooking up with indigenous folks in North America to try and sort of create that third space, but I don't know where it's gone. So, finally, what about those First Nations who have concluded treaties? And there are a few of them. If you look in the final agreements, you will find, in all cases, that the name First Nation holds its land in fee simple. There are a couple of exceptions, which we can get back to in a second. But essentially, the model is that the First Nation holds its land as a fee simple and then allocates interests to its members. And there are various models in which that occurs. Unlike earlier treaties, however, Aboriginal title is not formally extinguished. It, quote, continues as modified in the treaty. Continues as modified. And that movement between continuation and modification, that technical moment, there's a hell of a lot going on in there. We'll get to it in a second. Before we delve into the treaties side of the process, however, we have to step back very slightly. We have to step back to Niska. Now, Niska, as you may know, concluded a treaty outside the treaty process with the federal and provincial crowns. Niska was concluded its treaty at exactly the same time, in the late 1990s, that the status of lands question is on the agenda in the treaty process. So there's an important overlap between the two. There's an important overlap also because the NISCA model, which was basically carved out pretty much de novo, provided the template for the Crown in its dealings with the treaty process itself. So the NISCA agreement essentially is the same sort of agreement that you find in the treaty process. NISCA also accepted fee simple. Not surprisingly, there was considerable pushback from many treaty negotiators, First Nations treaty negotiators. So this is a quote from 2005 from some minutes of a meeting where all the First Nations chief negotiators get together with NISCA to try and figure out what NISCA has done. And you can see this person here, who's a negotiator from the island, says, you've extinguished. You've accepted fee simple, you've sold out, and you've ruined the rest, you've ruined the show for the rest of us. If you go to NISCA, however, you get a different story. So I spoke to Jim Aldridge. Jim Aldridge was the chief legal advisor to NISCA. He was involved in the entire process. Aldridge says this is not extinguishment. His argument, and that of many other, all other First Nation negotiators who have concluded treaties, is that this isn't a fee simple. Or rather, it is a fee simple, but it isn't a fee simple. I'll explain that in a minute. There's a bracketing or a re-bracketing that has gone on, they argue, in the way fee simple has been defined. Now, Aldridge said that the question of land holding was something that had to be negotiated from the ground up. Basically, what happened again is that NISCA agreed that the agreement in principle was that NISCA holds its land in fee simple. The Crown comes back and says, great, tell me, how do you hold your land? Initially, NISCA said, well, obviously we don't hold it as a fee simple. That's a Crown grant, that's extinguishment. We don't want that. So they looked at alternatives, but all those alternatives, things like allodial title, aboriginal title, were simply seen as wanting. So what Aldridge and his team do is dive back in to the common law, dive back in to feudalism, dive back in to the technicalities. And what he claimed to identify was an original fee simple, a fee simple minus, a fee simple way back in English legal history that was unsullied by the Crown. The Crown hadn't come and put on all its exceptions and accretions and provisions, the right of reversion, the ownership of subsurface rights, the right of expropriation. A purer fee simple, a differently bracketed fee simple, a fee simple minus. That's what he wanted, and that's what he said they got. But where does that fee simple come from? Is it a Crown grant? Well, he says, well, it doesn't say it's a Crown grant. You read the treaty, nowhere does it say that it's a Crown grant. That's because it isn't a Crown grant. It's all legal fiction, he says. It's all legal metaphysics. But to say that it's a fiction is not to say it's unimportant. The technicalities matter. In England, William the Conqueror might have acquired all title to the land, but in Canada, things are different, given the prior existence of Aboriginal title that is definitely allodial, right? There's no Crown gave the land to the First Nations to begin with. As such, the legal fiction changes. It's a geographic move. It says, here we are in Canada, things are different. Because we're in Canada and not in England. There's a different relationship. It doesn't say it's allodial. I'm sure he'd want to say it's allodial, but that's the implication. There's a different sort of fee simple that's at play here. This becomes a bit clearer, perhaps, when we go and look at those treaties that have been concluded or are close to being concluded. Comox on Vancouver Island are close to a final treaty, and they adopt a similar sort of logic. The chief negotiator is a guy called Mark Stevenson. Mark Stevenson was very suspicious of fee simple in his early days for precisely the same reason. But Comox gave him a mandate: we need treaty, we want economic development, get to treaty. So there was somewhat flexibility there. Officially, again, the AIP, the Agreement in Principle, has Comox holding its land as fee simple. Thank you very much. when I questioned him on this, I said, is it a fee simple? He says, well, it may look like one, but it isn't. It looks like a duck, it walks like a duck, it talks like a duck, but it isn't a duck. It isn't a duck, in part, for the same reasons as Jim Aldridge argued. The treaty doesn't extinguish Aboriginal title. Aboriginal title continues in the treaty. That means, logically, that it must still be in the treaty. There is no room in the common law for a fee simple grant that is allodial title. But you have to remember that Aboriginal title is continued. And there is room in the common law for a concept of Aboriginal title that is allodial title. Because all allodial title is ownership of land that doesn't come from the Crown. And then he says, I think you would have to come to the conclusion, because Aboriginal title is an allodial title, and that title is modified and continued, that it is an allodial title. I say naively, but isn't a fee simple allodial title a contradiction in terms? He says, yeah, whatever. Sure, it's not really important. He has other fish to fry. But essentially, he's just rewritten 1,000 years of common law legal history, as far as I understand it. At least the claim, at least, is that of a defeudalization of this doctrine of tenures. A reperformance, if you will, of what fee simple actually is. But he said it was a duck, right? So how can it be a duck if it isn't a duck? It can be a duck because it gets hooked up to other networks. It can align itself with other resources. It can act like a fee simple because you can register it in the land titles office, whatever the hell is inside that box. You can still hook it up. Overflows and brackets are at work. The magic effect of this is to turn it into a regular fee simple insofar as the world is concerned. You can't categorize it as fee simple lands in the standard property law sense because there are many other attributes to it. One of the attributes is that it can be registered in the provincial land title system, and so on. So inside the bracket, it's an allodial First Nations fee simple. Outside, or on the edge of the bracket, it's a regular fee simple. Fee simple is sort of moving. It's a boundary object, if you like, as it moves from one domain to the other, which I find fascinating. Tsawwassen has a similar sort of logic. Tsawwassen has concluded a treaty, and again, the treaty says Tsawwassen holds its land as a fee simple. Again, there's a pragmatic desire to reach resolution, to reach some treaty, obviously, because otherwise why would you be in the treaty process to begin with, but at the same time not to assimilate, not to extinguish. That space of reconciliation, that space of in-betweenness, you are, as one of my Tsawwassen respondents put it, within someone's legal system. So what's needed is a framework that, quote, helps others understand how Tsawwassen integrates into the rest of Canada, which is not the same as assimilation, nor is it a two solitudes kind of thing. It's that in-between space that they're looking for. Fee simple, a Tsawwassen fee simple, is said to offer that possibility. So these are the first guys I interviewed, so I walked in and said, so obviously you accepted fee simple, so you've extinguished, haven't you? Isn't this a crown grant? He said, no, it's an allodial title. No question about it. Tsawwassen fee simple is an allodial title insofar as Tsawwassen is concerned. You ask the Crown, they'll say something different, which is a story we can get to in a minute. That assertion is based on common law and Aboriginal title and all that stuff we've already talked about. But it's also one that is made performatively true through what one called the exercise of the tool, through jurisdiction. Tsawwassen has the capability to enact and perform an array of laws, including laws relating to land. By exercising that jurisdiction, we help cement our allodial title. That allodial title, in turn, gives us a basis upon which we have jurisdiction. Yet at the same time, they're happy to have this as fee simple for economic purposes outside. So fee simple on the outside, regular fee simple on the outside, Sawasan fee simple on the inside. And quickly, because I'm running out of time, this is a diagram that one of my respondents drew for me. And again, these categorical kind of possibilities, I think this is kind of intriguing. So over here, we have settler law, we have the Crown holding a allodial title, allocating fee simples, fee simple minus, they're calling it here, because they're all being sliced and diced by the Crown. Over here, in an analogous position, is Sawasan holding its public lands as an allodial title, insofar as they're concerned, and allocating its Sawasan fee simple interests to its various members. So I'll conclude. McHugh has a wonderful book about the challenges of reconciliation. And his argument is that reconciliation is actually harder than recognition. Recognition is fairly straightforward, challenging though it may be. Reconciliation, where the challenge becomes that of some measure of integration without extinguishment, is profoundly difficult. This requires First Nations to enter into the rights place of the legal system, as he puts it, or the constitutional compound of the settler state, requiring that Aboriginal peoples make, quote, hard and controversial strategic choices about inhabiting the colonialist constitutional system surrounding them, unquote. Now, much of the story around reconciliation has understandably been about the courts, about case law. I think that's clearly this is a crucial site. But I think the treaty process offers also an important window, and poorly documented window, on how that rights place might work, on its undeniable constraints, but also the creativity, the strategy, potentially the alternatives that can be carved out in this strange interstitial space. The space of reconciliation might be a bit more heterogeneous than we may suppose. Thinking about that, I think it's useful to think about bracketing, the way property is bracketed and re-bracketed through these technical forms and technical moves, where these brackets relate in complicated ways to that which is outside the bracket, so there's closure, but also drawing from that which is outside, the way those brackets become battle lines, understandably should become battle lines, the effect of which in arranging property's relationality is to arrange property's meanings. And I say meanings in the plural sense because there are multiple fee simples in this story. This is a story about many fee simples rather than one. This ultimately then is a story about the making of property, and also, in the same sense, a story about the making of space. Thanks very much.
Thank you very much, Nick. Are there already some questions? Grant?
Thanks for a really interesting talk. I guess it's not my area of law at all, but
not really mine.
And, it seems to me that these lawyers who you were talking to are just making it way too complicated. Because in Ontario, for instance, we have a number of decisions from the Ontario Court of Appeal that simply recognize Indigenous law as having a role in Canadian law. And it seems to me, going back and looking for all these old common law concepts and everything, overlooks the simple possibility of recognizing other laws, which we have the possibility within Canadian law, right? And just to give you an example of how it relates to this system, there had been some uranium prospectors on land that certain Aboriginal groups had claimed, but which hadn't been recognized by the province. And so the OPP, the police arrested these people who were protesting and so on, and threw them in jail. Well, not the OPP, through the courts. But the Ontario Court of Appeal said these people, these Aboriginal people, were acting pursuant to Indigenous law because William Commanda, the chief of the Algonquin First Nation of Golden Lake, had said that there ought to be a moratorium on uranium mining on this territory. So the Ontario Court of Appeals seemed perfectly willing to say the rule of law in Canada requires us to acknowledge the diversity of legal systems in Canada, and this is not the right way to proceed. And legal categories like injunctions and so on need to be modified to take into account the diversity of the system. So that's just why I sometimes think the common law is a lot more flexible.
Yeah.
We already have a whole area of law dealing with recognition of other forms of law within common law. So, here.
No, I entirely agree. Yeah, it seems like in some sense you're entirely right. Why not be a little more flexible? Certainly, I mean, from the Crown's side, I mean, I think First Nations negotiators would be delighted if there was some recognition of Indigenous law, but that's not even on the table. That's the thing. I mean, it's not even available to the
It doesn't seem to
conversation.
me it's up to the Crown since the Ontario Court of Appeals decided it. See what I
But
mean? That's
yeah, you think so? But there's
they
also
need to go back to school, law school.
but there's also a bracketing that happens in a sense around a bracketing around case law, because more or less, because what the Crown, this has been going on for so long. Of course, the case law has evolved in all sorts of, and it's evolved, another quantum step forward. But the Crown sort of brackets case law and says, look, that's over there. This is the treaty process. The treaty process. We recognise you have Aboriginal title. That's fine. Now let's just sort out the fine details insofar as they're concerned. But of course, case law has a way of seeping in to the process. And now, of course, with Chilcote, many First Nations would say, well, why the hell would we even go through the treaty process if we can, just litigate this and reach actually a more commodious understanding, a more expansive understanding of our title than these slightly enlarged reserves, as some have called them, that are being carved out under the treaty process. But you're entirely right. I mean, this was the question I had, even as a non-lawyer. I would come back to the Crown and say, well, I thought common law was a flexible instrument, and I thought you were capable of accommodating different sorts of tenures, and, isn't a condominium a kind of novel form of arrangement? You seem capable of doing that. Can you not, it seemed to be, and one of the challenges was actually what wasn't said, what wasn't available for conversation, even with the interviews I had.
Thank you. That was really interesting. I know nothing about law, so I'll just predicate on the comments on that. But I wanted to come back to this notion of certainty. And this is probably a completely naive question, but I was thinking about how Pat O'Malley links certainty to risk. And basically asserts that that's the neoliberal project, right, is to actually govern through uncertainty without ever making the promise that people could realize a certain future. And of course the law works, in my understanding of the law, works against that, because the law's class is always for some sort of certainty, right? But if Pat O'Malley is right that there is an element of risk involved in certainty, then I guess I want to ask you if you think maybe that there's something to that too, and then if you do, then what's the risk that the certainty is trying to correct?
So I know Pat O'Malley's work, but I'm not sure I know that argument in particular. So his argument
well,
is
he's basically arguing that the language of risk is really about the language of managing the unknown,
right.
And that we're in constant tension about what we can't know, we can't anticipate, and what risk gives us are algorithms we were just talking about having small children and having goldfish type memories when we can't remember words. So I apologize because I have small children and a goldfish type memory right now.
So risk is a useful governmental tool.
But that risk functions on uncertainty, right? And it has a predictive value, but there is no promise in risk, right? In the way that there's a promise in law. And so I wonder if
Yeah.
You know, if there is a discourse of risk going on here, then or of certainty going on here, and if O'Malley's right in paralleling certainty with risk, and I realize this might be a bit of a stretch.
No.
Then what's the risk that the law is trying to manage? Like, what's the danger here?
I genuinely don't know. I don't know.
Because it just seems to me like an incredibly complicated apparatus.
Yes.
So there's a lot of anxiety.
There's a massive amount invested in this. What work certainty is doing in this is not clear to me, and I say that as somebody who's thought about this and trying to pursue this. This goes back to that earlier response. In a sense, there's a sort of self-sealing logic that seems to be at work. It's the mandate, and it's just the mandate, and it's just the mandate, and it becomes impermeable to conversational critique. It's just taken as given that, which is bizarre, that the provincial economy and provincial system was predicated on some logic of certainty, which of course is untrue, because it's particularly a resource economy is predicated on massive uncertainty. Will LNG take off or will it not? Or, you know, and then suddenly there's been this eruption of uncertainty amidst this, right? Which has destabilized something. Not clear what. It's not about markets so much as it is, but it is about markets, but it's about something else.
Very much about that.
Yes, but it's not just.
I mean, I think, sorry.
Well, I just wanted to say it's super interesting because then there's another black box there, right?
Of course, there's many black boxes. Yes. And in fact, fee simple was I banged my head on the table with these lawyers. Tell me about fee simple. Unpack the box. It just was not
and
available.
It's just easy.
It just is. It's just easy.
That's so interesting.
And there's and so one of the papers I have about this is about easiness. And Bowker and Starr have a wonderful book on categories. If anyone's encountered this book, you may know this. If you haven't, you should look for it. And they have a methodological, so it's about categories and the way categories work. And of course, fee simple is a category, and also it's about categories, and so it's geography about categories. But some categories are easier than others. And their mantra is, the trick they say, I wrote it down, is to question every apparent neutral easiness in the world and to look at the work involved in making it easier. And so certainty is easy. Just well, Bourdieu said it's toxic. It goes without saying because it comes without saying, right? Did I get that the right? Anyway, you know what I mean? It's just given. But what's interesting with certainty is, of course, is that First Nations acknowledging the work that uncertainty can do, have strategically used uncertainty
as a tool of resistance,
as a political tool, right? So that why would we go with a treaty process if that closes down that possibility?
Which is super interesting because neoliberal governments would suggest that uncertainty is the mainstream way to govern, right?
Yeah.
To protect against resistance.
Yeah.
That's interesting. Thank you.
Other question? I had a question. I was wondering if the parties had agreed to a different bracketing of the stories, because you are saying that the Crown and First Nations have a different interpretation of the symbols. And so I was wondering if and when the challenges will come to another stage, which is the courts, what will happen? Because it just seems to be that, like, was the bracketing process part of just for the First Nation to be able to convince their people of signing up? Or was it like really trying to gain something? And what will happen when they'll need the arguments in court?
I don't know. I mean, nor am I judging these strategies. I mean, that's not my place. But that's the obvious question. I mean, it sounds really good, but if you ask the Crown, they will say around LISCA and all these other treaties, we hold the local title. I guess for me, one question is, under what circumstances might that be challenged? And I don't know, I can't think of a circumstance under which it might be challenged, but one could conceive of of a challenge. Yeah, then it goes back to the courts. But I suppose if we think of Sawasan,
the challenge is about the attributes of property and the extent and the border, the boundaries of it, I guess, could happen.
It could. Yes, and there has been case law around overlapping, or legal disputes around overlapping claims and so on. But the question of what the land holding, what the title actually is to the land, how the First Nation holds its land, the very different ways in which that's understood. I'm not sure how that would, under what circumstances that would be challenged. It would be interesting to see how that would unfold. I think it would be problematic for the First Nation, quite clearly. Which is why perhaps Sawasan are trying to sort of make it true through enacting jurisdiction and performing a allodial title, as it were, on the ground. And I'm not a lawyer, so and I can't comment on whether that will be successful. I mean, there are bigger questions to ask about how fee simple becomes successful in regular fee simple. Is successful in the world, and I think there are interesting points that we could make there about what, if fee simple isn't true, it's made true through the way it lines itself up with credit institutions and titling systems and so on. Can we not make that other form of title true by rearranging those relations, by making it true in a sense, in a performative sense?
You might want to take a look at the Port Canal project, and I think this is one way of maybe testing the question that was just posed.
Yeah.
But the Port Canal project is a major natural resource project, and I believe it runs through Nisga'a territory, and so there are some questions, right, about the issue of property and what the Nisga'a understand in terms of their property and what the Crown understands.
Okay. Interesting.
Okay.
Let's look at that. Okay, thank you.
By the way, I work in that area, so
Good.
that's one reason why it's
No, I appreciate that.
I have perhaps a naive question. Is part of the tension about opening up the idea of fee simple around the fact that in British Columbia, such a small proportion of the land in British Columbia has actually been resolved in the treaty process? So you have an enormous amount of land which is up for contest in a sense, and a great deal, and we know that land has different kinds of value attached to it, and that value changes all the time. And that part of it is that because there's so much land right now, you don't really know what the value at this moment in time of all the land is, and nor do you know what it is in the future.
Yeah.
And so trying to open it up and incorporate some different notion of holding land really becomes really problematic because there is such a poor understanding of what the value of the land is, perhaps on the part of all parties.
The value of the land rather than the extent of the land. Yes. It does put the cattle amongst the pigeons. I mean, 99.6% of land is non-mineral. It's not reserve land. So it's a vast amount of territory. And the majority of that's crown land, presumably. So it does open that up, I suppose. Although you don't see it necessarily discussed as such. Again, precisely what's so worrisome about uncertainty is not always clearly articulated. I mean, I think one of the interesting things is the way in which Crown title and quote regular fee simple title might bleed into each other. And there has been some sort of occasional conversations about if we make Crown title uncertain because this legal burden, does that then implicate my title? And no, it doesn't. The bracket must be maintained. There's always, I think, that a worry in the back of the room about that possibility.
I guess I was a little bit unclear about how you meant bracketing, just because I'm familiar with it from philosophy and phenomenological concept of bracketing. But what your discussion did make me think of a lot is the discussion in philosophy of science literature about practice. Because the more I think about your responses and the nature of your study and so on, the more I think that what appears to have happened here is that the concepts of property that are being used are bracketed by the practice of these particular lawyers involved in a particular process, and which has made them made it impossible for them to step outside to see conceptually the broader, the greater options available. The reason I don't understand the problem these lawyers have at all is because the way I learn property is a bundle of rights, and fee just simple just has to be, there are these 5 things that are bundled together. But you could bundle together 10 different things, or 2 different things, and property is inherently a flexible concept the way I had learned it. So I think that what the problem must be is, as you described, these people are so involved in some kind of negotiation with the set parameters and are unable to see outside it. So I just thought, looking at science basically as a practice rather than a set of ideas applies here. This is a set of lawyers practicing something, not really about the ideas that they're deploying.
I entirely agree. I think it's absolutely practical, and I see the process of bracketing as one of those practices.
It is, eh? Okay, that's what I wasn't sure. Okay.
So if we think about it in terms of categories, it's a question of building categories, which is inherently practical. And it's also a question of, you can build categories in multiple ways. You can build a category in a not A way, which is what the Crown is doing, or you can do a sort of more prototypical form of categorization, where you have some ideal type, regular, fee simple, and then gradations of property forms that more or less relate to that possibility. So absolutely, it's practical. Again, why that narrow sense of the possibilities of the bracket is not something that I was able to get access to, because of course you're asking people, why are you invisible? Why are you blind to something? They're not going to respond necessarily. I mean, some of them were more thoughtful, I should say, and they did have arguments about the worries that this would occasion. If we open up the bracket, they talk about carving out, that you wouldn't then be integrated and connected into this process of reconciliation as they understood it. But still the First Nations many of them.
I think just to add to that, where it starts back from is the fact that when I was negotiating land claim agreements, we're given a set of negotiation instructions that we don't necessarily develop. It's developed at a higher level. And with the incorporation and inclusion of thinking from central agencies. So go figure that we're just following marching orders, mostly.
Yeah, this is back to the mandate, which is this magic, like certainty, the other word, which is mandate. And no one can quite remember where the mandate came from, right? It's 20 years old, right? And I tried to actually excavate that and talk to some of the people. And of course in BC, there was no negotiations going on the part of provincial negotiators. So they had to sort of develop a mandate from the ground up. And so you get some federal negotiators who come over to the province and bring their wisdom from what happened in Yukon and various other jurisdictions. So there is an interesting story, but I never, it's now ancient history, so it's hard to. It becomes again self-sealing, right?
Yeah,
it's just the way it is.
I had a question on bracketing as well, prompted from what you said. And the question is the bracketing performed here to neutralize, to make parties neutral, in the way, for example, in philosophy, Habermas talks about in discourse ethics, that you bracket out differences? Or is it used to create other, or perhaps both? So in other words, is the law used in some ways to neutralize supposed differences? Or is it used to actually create a type of argument through the same process?
So those are two different things.
Well, I'm not sure, so.
Okay. Yes. To some extent, I purposefully did not inquire into the effects of the bracketing. I mean, in part because I'm not accessible. I don't have access to that. I don't have access to that because I'm not native. I don't have access to that also because there are methodological challenges in accessing that. My interest was, in a sense, in the practice. I mean, how do you build a bracket? How do you make fee simple when it becomes complicated? In a sense, was one of the organising questions insofar as the Crown was concerned. Well, how do you take How do you enter into a legal system that is the instrument of your dispossession and try and make that work in ways that are more accommodating to your own interests? What technical, practical work does that entail? Now, clearly it has effects. And we can speculate on what this might be. But in a sense, I bracketed that. Like any project, we bracket.
We have time for one last question. 2 minutes, yes?
So I'm also coming here with a very naive question. So the way you presented it, kind of go along the lines of some of the other questions. Why is all this taking place? So I'm not a lawyer, and so I wonder, is there like some worry about having this, blank space in the back, like all the space, and planners need to know this industrial spaces, residential spaces, and need to map that space and know how that space can be used, who it belongs to, for legal purposes, all that. So there's kind of the legal challenge of what comes with it. So would it not just be alright to leave it like that? So coming along the lines of having the possibility of having multiple legal systems, just put on the map, this is a regional land, and that's it. And no worries about kind of colonizing it and making it into a settler space, or defining it in settler terms. So everything that you've said comes to your last comment about this is all avoiding people having to work with a settler system and equal partners in it. And that reconciliation work, it's not about how can we work together as equals, but we set the rules that you were saying, and it's all about them using or working with those rules to the best of their advantages. Is it just
absolutely, no, there's multiple things there. I mean, I was speaking to a very, very senior provincial negotiator who was actually very candid, and at some stage in the interview, I'm banging on about fee simple, and there's a section 912 or section whatever, He says, look, it's all about power. He said, it's a power game. He said explicitly, and basically we hold the cards. That's the way it is. Absolutely, that's entirely the case. So it is about power, but it's power of a particular sort. It's power. It's legal power in a sense. So we need to. If we're interested in power, we're interested in law. We're interested in trying to figure out how power becomes possible. Power is not just a thing in the world. Again, something that's made stable and performed into being. How do we interrogate that? How do we make sense of that? And it seems useful for me to dig into this site as one place in which power is being put to work. Now, why the treaty process is another question, and that's an historical question in part that relates to Oka and to the late 1990s, and the fact that for 150 years the province refused to acknowledge any form of title on the part of First Nations to their land after Douglas and the Douglas treaties, and an understandable resistance to that, which changed the government and left-centre government comes into power, and there's this attempt to come up with something new. But I would think the motivations behind it as being multiple. I mean, as some of them having something to do with inertia, bureaucratic inertia, right? People are in a system, they're being paid, you just keep going, right? It's a job and whatever. It's a career now for many people on both sides. So I think there are multiple motivations. And I resist the idea of trying to find one singular logic. It depends who you are and your position, yes. Exactly. And what certainty is open to multiple.
Well, thank you very much, everybody. Thank you, Nick, for a very thoughtful and inspiring talk. It made me think of all the categories that we should bracket and in other areas of law. By all means, please take food on your way out, because we have plenty.